How do you sever joint tenancy? Have you ever wondered how to change the way you own property with someone else? If you own property jointly, you might be considering severing that joint tenancy. Let's break down how you can do this and what it means for your estate planning. Joint tenancy is a type of property ownership where two or more people share ownership with the right of survivorship. This means if one owner passes away, their share automatically goes to the remaining owners. However, sometimes you may want to change that arrangement. Severing joint tenancy changes it to a tenancy in common, where each owner can transfer or inherit their share independently. One way to sever joint tenancy is by recording a written declaration. This document must clearly state your intent to sever the joint tenancy. You can execute a deed that transfers your interest, even if it names you as the transferee. It is essential to record this document in the county where the property is located. This provides notice to other owners and helps prevent any potential fraud. Keep in mind, a simple will does not suffice unless it is publicly recorded. Another method is to convey or transfer your interest to a third party or even to yourself in a different form of ownership. This action breaks the unity required for joint tenancy, turning it into a tenancy in common for the transferred interest. You can also sever joint tenancy through mutual agreement among all joint tenants. This agreement should be documented and recorded to ensure it is effective. If you find yourself in a situation where a court is involved, a partition judgment can also sever a joint tenancy. A court may order the property to be sold or divided among the owners. However, simply filing a partition action does not sever the joint tenancy. It happens only upon the court's judgment. Divorce proceedings can also lead to severance as part of property division, with the court directing new deeds to be recorded. Other legal actions, like execution sales following a judgment, can sever joint tenancy as well. When considering severing joint tenancy, it is crucial to document and record the severance properly. This ensures that all parties are informed and helps avoid disputes over ownership. Severing joint tenancy also changes how property interests pass upon death. The right of survivorship is eliminated for the severed interest, meaning it will pass according to a will or intestate succession instead of automatically to the surviving co-owners. In estate planning, severing joint tenancy can be a strategic move. It allows property to pass according to your wishes rather than automatically to the surviving joint tenant. This can be especially important for estate tax planning and ensuring that your heirs receive the intended assets. If you decide to sever a joint tenancy, typically, you would execute a deed or written declaration stating your intent and record it with the county recorder. For example, you might prepare a deed transferring your interest to yourself as a tenant in common, effectively breaking the joint tenancy. In summary, severing joint tenancy is a deliberate act that requires proper documentation and recording. It changes the nature of property ownership and can have significant implications for estate planning and tax considerations.